Good morning. Welcome to the Court of Appeals. This is the second of three matters that we will be hearing argument in today. One lesson we learned during COVID is the convenience of setting our matters at hour intervals rather than having everybody come and gather and have their cases called. More efficient for us and presumably more convenient for counsel. We appreciate counsel being here. I have a note that counsel for appellee, while present, does not expect to argue. She's here at counsel table. You haven't formally waived argument, so I guess if you hear something completely disastrous that requires you to come out of your seat, we will hear from you. But otherwise, we're expecting to hear argument only from appellant. And therefore, appellant is not saving any rebuttal time.
Correct, Your Honor.
So I guess if the spirit were to move counsel for appellee, we'd have to give you a little rebuttal time, but I would countenance very much against that. I assume this is a considered and thoughtful opinion. You've discussed it with your client. Of course, appellant has the burden of persuasion on appeal, so that may well be a logical choice. We won't second guess it in any event. And I'd invite you both to state your appearances for our record.
Ben Lusty on behalf of appellant, Your Honor, who is listening on the live stream.
Very good.
Mary Dice Brown for appellee. Lucas John is here next to me.
Very good. We appreciate the appearances from counsel. And Mr. Lusty, we will hear your argument whenever you're ready.
Thank you, Your Honor, and good morning. May it please the court. I wish Ms. Brown a speedy recovery as well. The primary issue that appellant wishes to raise with the court is really found in section 30-3-34.5, which has to do with when and how supervised parent time can be ordered by the district court and what has to be in place for that order to go forward. The legislature has used, I think, some very deliberate language, some very deliberate verb tense, and has placed some, I don't know that severe is the right word, but some serious conditions on when supervision is to be used as a tool in parent time situations. In fact, the legislature used the term least restrictive means, which comes straight from the United States Supreme Court's jurisprudence with respect to strict scrutiny and narrow tailoring.
Maybe I'll start with a question there. That one of the cases that you cite on least restrictive means talks about, and I may not get the quote exactly right, but where there has been some other means offered. And I've not seen anywhere where you've suggested that assuming that there is potential harm, then there was a less restrictive means than supervision. And that your argument in your brief really is, well, there wasn't harm, so there shouldn't be supervision. You went all the way through least restrictive means legal analysis, but then jumped right back to, but there wasn't a finding of harm. You've not offered what's the alternative.
And in fairness to myself and my advocacy, that's because we lack the threshold finding of harm. And so I think, Your Honor—
Which really says to me that we're really setting aside the least restrictive means argument.
Right, which is what—
Then let's go to the harm.
Correct, Your Honor, and the purpose being of the citation to the least restrictive means is that we have to have a finding of harm, and it's not just some—
And maybe that's where my second question is. The statute does not say that there needs to be a finding that the child would be subject to harm. It says that there needs to be a finding of evidence that the child would be subject to harm. In my mind, that's very different. That if the court finds that there's evidence, then we can go to supervision. And it seems that the court did find evidence in the fact that she had put in a multitude of orders over years about, let's have some clean drug tests.
Yes.
None of them were complied with. We've got evidence that there may be harm if we send the child back with mother.
So I think that what that problem with that gets us back to is if the court finds evidence that the child would be subject to a physical or emotional harm. And that gets us back to the present tense, would be.
Well, there is evidence that she would be.
Except that the district court specifically weighed that evidence, found mitigating, helpful and hurtful evidence to my client, mitigating, aggravating evidence is what I'm trying to say, weighed it and said, it's unclear to me if there is harm.
Well, she said it's unclear if there would be harm.
Yes.
But I've got aggravating evidence, and so I've got evidence that could support that there would be harm. And in my mind, if you read that,
Yep.
evidence of harm really means we've got evidence of a potential for harm, and then she says that exact thing. Given her noncompliance with the court's prior temporary orders, she potentially could be in danger. We have evidence that there could be harm.
Yes, and potentially and historical evidence where I think the verb tense still speaks to a present risk of harm. And so if the finding, okay, if this court is going to say, well, you just have to find historical evidence, then we have to reconcile this would be. And then we have to show, is there still a temporal valence between the historical evidence and the party we have today? Because if we look back, and we can even go down to subsection 5 and 6, where there's discussion about what needs to be in place or standards that the parent can meet for the order to be lifted, that anticipates that a finding of harm or a finding of evidence that there was harm could become stale, could no longer be operative, could no longer present a concern for the child's best interest. And then I think we still have, and I think what the statute still speaks to, is a necessity of finding a temporal connection between historical evidence, which there's no doubt is there, and the present condition. And where we've had the judge who heard the evidence, evaluated the aggravating and evaluated the mitigating circumstance and said, I can't find an ongoing risk of harm, then the larger language of the statute, which speaks of fundamental liberty interest and least restrictive means, counsels against accepting that as sufficient, because then we get to a question where what quantum of evidence is going to be sufficient to support a finding of harm.
And in that circumstance, I would go with the language of the statute, which just uses the word evidence and doesn't give us a quantum. And so if there's any evidence that there could be harm to the child, then the trial court can impose supervision.
I think, though, that leads to a larger problem, which is, let's say that the evidence that's found is, say, a scintilla, the least standard of evidence that would be necessary to support that. Given what the legislature has said about fundamental liberty interests and least restrictive means, would that really cohere with what appears to be the policy set out in the first subsection, that says this is a fundamental liberty interest of parents and children? And so if the standard is going to be any scintilla of evidence, then I suppose we could have a situation where during the heat of a nasty divorce where the parents are bad to each other but not necessarily bad to the children, there's evidence presented that father or mother...
And in that case, maybe we'd need to dig that deep. Here, I think there's more than a scintilla of potential presently for harm, where the prior findings were that the ongoing drug use created potential for harm, and you've not shown, you meaning your client, has not shown that you are past drug use. Therefore, right now, there's more than a scintilla of evidence that there could be harm if we leave the child with you, unsupervised.
Except that the district court didn't make that finding. The district court said, I'm evaluating all this evidence and I can't find a risk of harm. It was one of the things that was specifically.
No, I can't find that there would be harm.
That there, excuse me, correct, that there would be harm. And that matches the verb tense exactly in the statute. And I think adheres that there is no present risk of harm found, which I think is the predicate finding that's required by the district court in order to impose supervised visitation under this subsection. Now, that naturally leads, and given that I've got 6.5 minutes left, I think that naturally leads to the subsequent part is what standards are going to be in place for the lifting of it, and what are going to be the conditions of supervision, because even if supervision is ordered, there still has to be an analysis that there are not other least restrictive means that are available.
But
So
before we get to that part,
Yes,
can I keep you on the first part for just
Yes.
a little bit? And yeah, husband's key point, at least one of his key points, as I take it, is that you can have situations in which a parent was clearly a danger in the past. They disappear for a couple of years. I mean, this is this case.
Yes.
They disappear for a couple of years. They show up just on the eve of trial, and we just don't really have any contemporaneous information. We don't have any current information. And his sort of big thrust argument is that in that scenario, we should be able to protect the children. Everybody agrees we should be protecting children. And it's almost as if we should be able to assume that the parent remains a danger unless they've proven otherwise. Two questions. One, how would you respond to that generally? And two, how could a district court protect kids in a scenario like that one, in which the time gap prevents the court from having evidence of whether they are a present danger?
Yes, Your Honor. So first, with respect to the presumption, I forget which section of 30-3 it is, but we have a presumption of joint legal custody. We have a presumption of parental fitness. We have a presumption of non-supervised parent time. We have a presumption of minimum parent time for the non-custodial.
I mean, it's in this provision, so the first line of that subsection, I think, is what you might be thinking of.
Well, in addition to 34-5, we have, forgive me, I can't remember them all, but we have a presumption of joint legal custody. We have a presumption of minimum parent time in 30
We'll look it up, yeah.
Yeah. Presumptions have legal meaning, and they have evidentiary meaning. And what they mean is that if there's not evidence to overcome the presumption, there's not evidence to overcome the presumption, and we go with the presumption. I recognize that creates a bit of a logistical problem, where the district court says, okay, I've got this gap in evidence and I have these presumptions, what should I do? District courts always have discretion to schedule their trials. There's nothing that said the trial had to go ahead. The district court judge could have said, I know I've got trials scheduled, I'm going to continue the temporary orders. I want briefing on this, or I want a trial briefing on this, I want further evidence of this, I want to hear from a custody evaluator, I want to appoint a custody evaluator under the Code of Judicial Conduct rule. I think those are the tools that the district court judge has when we're faced with a situation like this, and I think that those are the tools that the statute would presume would be used prior to barreling into, I apologize, barreling was not the right word.
No.
Prior to moving forward into a permanent order of supervised visitation after a trial. Because there's a world of difference between a temporary order and a final order. This is an adjudicated decree that we have to go through certain procedural steps to overcome that we don't have to go through a temporary order. If the district court judge, who is charged with the protection of the best interests of the children, feels that they do not have the evidence to enter appropriate permanent order, then the remedy is to continue trial.
So let me ask you the sort of next layer question to that. Let's just suppose that the district court decides to not postpone the trial, but wants to go ahead. Would you agree that there's a scenario in which the district court could find, based on past danger, that there's still a danger, sort of by inference? In other words, you were a danger 4 years ago, 3 years ago, 2 years ago, and even though there's been a gap, I'm still going to find that you're still a danger because you were a danger in those past years. Do you agree that's conceptually possible?
Conceptually, yes.
Okay, so then let me ask the question, and then I'll be done.
Depending upon the evidence.
Depending on the evidence,
yes.
and right. Suppose here that Judge Chon had instead said, based on the evidence before me of mother's past drug use, I find that she's still a potential danger. I find that the fact that she was an addict 5 years ago to be so compelling that I'm going to find now that she's still a danger. What would have happened in that appeal? I know it's not this case, but I'm just thinking this problem out. What happens at that point?
Given the adequacy of the findings and the evidence to support those findings,
Yeah.
they could be subject to appeal. Of course, appealing findings are a very hard thing to do.
Right.
And likely in that situation, the non-custodial parent would have to move forward with those findings.
I suppose the reason I'm sort of getting at this is I think both briefs are sort of circling around the same problem, which is how do you protect the kids in this sort of quirky scenario in which you've got a past danger followed by a period of absence. And I suppose one of the things I'm just wondering aloud here is maybe that's part of the answer, is whether the district court in that kind of scenario could say, hey, the evidence of past danger was enough that I'm finding that it still exists as one sort of means of solving this problem or not.
I don't deny that that is a plausible outcome under the statute. It was not the outcome in this case. It was not the finding in this case. But where I really, and I've felt the concern, and I see very clearly where this court is concerned, the district court is not without tools to avoid these types of outcomes. Guardians ad litem can be appointed. Special custody evaluators can be appointed. Temporary orders can be continued. Evidence can be taken in trial. The trial can be continued until additional evidence is taken. This is not done in a jury trial where we have to have concerns about scheduling the juror's time. I've seen domestic relations matter continued for trial over a year sometimes when there's bifurcation and there's complicated issues that arise. So yes, the district court has tools to do it, but the district court is also constrained by what the legislature prescribes when it used this very extreme tool of supervised visitation. And the problems that we finally have here, and my time is almost up, Your Honor, but there's no guidepost to getting past supervised visitation. There's no expectation on how long it will last. There's nothing really to say.
Well, let me push back on that, and I recognize that the time's about to expire, but feel free to answer the question.
Sure.
As I read the district court's order there, what the district court was essentially saying, it was almost outsourcing that second part of the inquiry. The district court was saying, look, I'm going to send you to a reunification therapist, and if and when the reunification, well, maybe not if and when, if the reunification therapist says all's clear, then at that point we'll consider unsupervised parent time. Why isn't that specific enough to deal with subsection 5 under the statute? I mean, that seems to be a fairly specific condition. Get the okay from the reunification therapist.
So my concern with that, Your Honor, and the answer I would give is that, for one, we need to have the reunification therapist presenting their conclusions as to what is advisable for the court to make its order under the aegis of the rules of evidence, so those recommendations can be subject to cross-examination and examination. That's going to be expert testimony. We're in an adversarial situation. Litigants have the right to question the recommendations of a reunification therapist, not just have it made by judicial fiat the order of court when there's no way to really question it. And second, the statute says specific goals and expectations set by the court. And for the court to simply say, do what the reunification therapist does, how do we appeal that? How do we challenge that? How do we have on our chalkboard at home, these are the 4 things, 5 things, whatever it is in this specific case that I need to do to get back to having a normal relationship with my child. That's, I think, the problem with that proposal, Your Honor. Unless there are other matters, we'll respectfully submit our argument.
Thank you, Mr. Lusty. It strikes me that your argument did not go far afield of what was briefed, and we understand your position, Ms. Brown, quite well from your brief. So we appreciate.
May I just pop up here just for 1 second? And Judge Tenney, you did notice the reunification provisions. And
I did.
I wanted to go ahead and point out paragraph 18, which specifically requires that it be brought back to court after reunification, whatever procedure the therapist does there, and then it's subject to the court and to the judicial processes. And so it's not as if it's outsourced entirely. It's essentially an investigatory process brought back to the court, and everybody gets a chance to go again. So.
Mr. Lusty, I assume no rebuttal to that observation?
No, Your Honor, I'm satisfied with the arguments.
Very good. We will take the matter under advisement then. Ms. Brown, we join Mr. Lusty in wishing you a complete and prompt recovery. and we will be in recess until 11 o'clock.